Running the files. Oh. Okay, on the record in the matter of the people of this city of Lansing versus Shaquille Rhymes, file number 21-01039. Council appearance.
Assistant Public Defender John Lee on behalf of Shaquille Rhymes.
Okay. Shaquille Rhymes, you can hear us? I can't hear you. You need to unmute.
Yes, I can hear you guys.
Okay, today was the date and time set for a probation violation hearing. You were previously arraigned on the violation. That's a violation that you failed to continue on your scram tether, that you was cut off back on June 1st, 2022 for non-payment, and that you violated the order of the court from May 17, 2022 by failing to participate in outpatient counseling as directed. And so you were advised of your right to have a contested hearing. My understanding is that you do not wish to have a hearing today.
Yes.
You do?
No, I do not wish to have a hearing today.
Okay, so you want to plead guilty to the violations?
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes.
Okay, you can put your hand down. Anybody threatening you to give up your right to have a contested hearing today?
No, ma'am.
Has there been any promises made to you in exchange for you pleading guilty to these violations?
No.
As to the violation that you violated the amended order of the court from May 17, 2022 by failing to participate in outpatient counseling, how do you plead?
Guilty.
As to the violation that you failed to continue on your scram, that it was cut off on June 1st, 2022, how do you plead?
Guilty.
Factual basis, counsel.
Thank you, Your Honor. Ms. Rhymes, is it true that you were sentenced in regard to an operating while intoxicated conviction in August of 2022 to a period of probation?
Yes.
And is it true that you were ordered by the court on May 17th, 2022, I'm sorry, 2020, you were sentenced in, okay, I'm sorry. Is it true that you were ordered by the court to complete outpatient counseling?
Yes.
And did you fail to complete outpatient counseling?
Yes.
Okay. Is it also true that you had a scram tether that was turned off for non-payment?
Yes.
No further questions, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. The probation officer did complete a probation violation recommendation indicating here that they met with you back on December 6th, that you did report still drinking alcohol and smoking marijuana, although you knew that you were supposedly on probation and at least in a warrant status. She states here that continuing previous probation officer's recommendation, they say you have a history of non-compliance while on probation and substance use. Mr. Lee, you can address the court before I impose a sentence.
Thank you, Your Honor. Ms. Rhymes reports that around the time where she was making no payments on her scram tether and struggling to comply with the court, she was also evicted from her home and was struggling in her life. She reports that at this time she is in a much more stable environment, that she is working full-time at Rosewood Senior Assisted Living. Although she is out right now with COVID, she fully anticipates going back as soon as she is well. She has expressed to me remorse for the fact that the probation did not go the way she wanted it to go, nor the way the court expected it to go and ordered it to go. She is asking the court for a chance to complete probation. She will, as she has expressed to me, complete the outpatient class and/or counseling that the probation officer has recommended, and would like an opportunity to complete probation successfully. Thank you, Your Honor.
Does your client want to make a statement at all?
Ms. Rhymes, would you like to make a statement to the court?
No, sir. No.
Thank you.
Okay, I'm reviewing the file. During the time, ma'am, that you were on probation, you had multiple violations. I see at least 4. However, there were also some waivers of probation violations, all relative to use of drugs and alcohol and/or lack of testing. And so even before we got to the point where it was June 1st, 2022, and your tether got cut off, you were already not being compliant with the court's order. So it doesn't place you in the most positive light as it relates to how we want to proceed today. However, your attorney is indicating that you're now in a better position. We're going to give you the benefit of the doubt. I'm going to continue your probation. I'm going to sentence you to 30 days Ingham County Jail. Continue your probation 6 months, and I will dismiss the 30 days upon successful completion of probation without any further violations. Any more violations, you'll serve the 30 days. Do you understand that?
Yes, ma'am.
Okay, so you need to report to probation on your regularly scheduled report date. Do you know what that is?
No, ma'am, I don't.
Okay, we'll have Ms. Bayless get in contact with you since you do have COVID. I won't obviously require or want you to come into the building. We will have her follow up with you and via Zoom, and then you'll get your new scheduled date, okay? If you don't hear from her within the next 7 days, you contact the court probation department, okay?
Yes, ma'am.
Do you have any questions?
No, ma'am. Will
Any
you guys
additional-
send me anything regarding today?
We
In
will
the
not.
mail, or just to
You'll
contact
go
her?
over with your over with your probation officer, but we won't be sending you anything regarding this hearing.
Okay, so just wait for her to call, and then if not,
Yeah.
contact in 7 days.
That's correct.
Okay.
All right, you're all set. Thank you. Amari McPherson. On the record in the matter of the people of the city of Lansing versus Amari McPherson in file number 23-01781. You're Amari McPherson. Today was the date that was scheduled for a probation violation. Arraignment, however. Okay, I have a request and summons for probation violation. It alleges that you have committed the following technical violations. That you tested positive at EverHealth on November 11th, 2023 for alcohol with a result of an ETG of 12,020.37 over ETS of 2278.1 nanograms, and THC at 348.94 nanograms, and for THC on November 16th, 2023, with a result of 707.11 nanograms. There's also a violation that you failed to provide evidence of GED enrollment, and a violation that you failed to provide proof of your inability to work. And so you have the right to have a contested hearing. You have the right to be represented by an attorney at that hearing. If you're found to be in violation of your probation status, your probation can be terminated and you can be sentenced to a term of jail time. Do you understand that?
Yes, ma'am.
You also could have your probation extended. You could have additional oversight or programming ordered if the court deems necessary. Did you want to request court-appointed counsel to represent you?
Yes, ma'am.
The court will enter a plea of not guilty at this time, and note that you are requesting court-appointed counsel, so we'll set this for the hearing. January 8th at 1:15. January 8th at 1:15 will be your hearing, okay?
Yes, ma'am.
We'll get you a copy of your notice to appear. Do you have a phone with you? Oh, is that a yes?
Yes, ma'am.
Okay, we're gonna get you on Zoom so you can meet with the public defender, okay?
Okay.
And he can get the information from you. You can have a seat. Okay, on the record in the matter of Credit Acceptance Corporation versus Diamond Nolan, file number is 18-02591. Appearance, please.
I'm here.
Is there an attorney present for credit acceptance? Okay, this matter was scheduled for a hearing today at 2 o'clock, and that is for an objection to installment payments. Let's see.
Judge, I'm sorry, what was the case number on that?
18-02591.
So it looks like that's a file with my office. I didn't have it on my docket today, but I can take a quick look and
Okay,
see
I'll
what's
go off the
going on.
record so you can, look, catch up on the file.
Thanks, Judge, appreciate that.
No problem. On the record in the matter of, oh, she might be on that one too. Plaza Services LLC versus Angela Welch, file number 19-00868 GC, counsel appearance.
Good afternoon, Your Honor. Attorney Ashley Nonis Hartman on behalf of plaintiff.
Anybody present on behalf of Angela Welch? Okay, no one is in the virtual courtroom responding on behalf of Ms. Welch, nor is anyone in the physical courtroom representing Ms. Welch. Today was the date set for a review.
That's correct, Judge. And to date, the defendant has not made any payments or contacted our office.
Okay.
And if I recall correctly, the last hearing we were at, I think you had told her that if she failed to comply, that you would set aside the order. I'm not sure if you want to just do that today or if you want us to file an affidavit of noncompliance.
You should file an affidavit of noncompliance. Let me see who this is in my Zoom room. I'm just looking at my last order in the file where I did order the installment payment of only $20 every week. Let's see
That
who
was
this
on
is.
August 17th.
Yes. Who's on the Samsung SM?
Mari McPherson.
Okay, I'm gonna put you in the private meeting room with Mr. Lee. Okay, yeah, if you want to, if you could file an affidavit of non-compliance, then the court will grant that and set aside this installment payment order.
Thanks, Judge. And then I'm ready to proceed on the other one.
Okay. Back on the record in the matter of credit acceptance versus Diamond Nolan. And this matter, I'll take the council appearance, please.
Thank you, Your Honor. Again, for the record, Attorney Ashley Nonis Hartman on behalf of plaintiff.
Okay, then Ms. Nolan is also known as Diamond Ward now, is that correct?
Yes, that's correct.
Okay, she's present via Zoom, and you do not have an attorney representing you?
No, I do not.
Okay, today was the date and time that was set for an objection to, it says installment payment order. I have a response to your request for a new installment payment order. Did you receive a copy of that, Ms. Ward?
Let's see. Yes, I believe so.
Okay.
I got a
And so-
couple different things in the mail. I'm sorry.
Okay, this would have come from the plaintiff's counsel and where they indicate their response to your motion for installment payment order. They indicate that you have an amount for against you in a judgment of $10,803.20. That's from October 24th, 2018. That currently the balance is still $8,959.94. That you previously had an installment payment order of $100 per month, and we set this matter for a review date for November, and that you had not been at the November date. You reported that you had not been making any payments. The court did set aside, well, you failed to appear, so the court did set aside the installment payment order, and you received that order under the 7-day rule, and that's what prompted you to file a new request?
Yes, so I had been making payments, but I got really sick and I was taken off work for a few months. And then I don't work in the summertime because I teach. So I wasn't able to make the payments every 2 weeks like I was. I was kind of making them here and there when I was able to get money. And then I didn't get anything in the mail and I thought I was supposed to. So I didn't remember the day that we were supposed to meet in November. So that's why I was trying to reschedule it. I wasn't able to do a Zoom because I was at work. And then I got the notice in the mail that they were going to decide to start garnishing my wages. So that's why I was trying to refile to go back to the original agreement of the $100 a month, because honestly, that's all I can afford.
Well, let me ask you this. Why did you have to wait for you to get a notice of garnishment before you started trying to make payments again?
No, I had started making a payment. I had only been working since the middle of September. So I started making those $50 payments every 2 weeks. So it's $100 a month. But when
So
it's
you
time
made
to go,
payments, you made payments in October?
I did make payments in October.
Is that accurate, counsel?
That was the last payment we received. It was on 10/14, $100. But at that point, she was $450 behind. She had contacted our office on the 7th of November, and we explained to her that if she can catch up on the arrearage, we would continue the payment plan. But she did not, and then she didn't make any further payments after the 10/14 payment.
Okay,
I'm sorry, can I say something?
yes, you can.
When I had called the office a few times and I had noted that I wasn't working, and they told me, whoever I spoke to, because I never actually spoke to a lawyer, I just talked to someone that answered the phone. They said that to keep letting them know that I wasn't able to make them, and when I was able to make the payments, to send them in. So that's what I was doing. But I never was told that if I didn't catch up that they would cancel it. I wasn't told that until I went down there when I got the notice in the mail. No one said that to me. And I got confused because I thought that when I filed to have the payments how they were, I thought that it was going to be put on hold, and then my wages were garnished. So I just got all confused about that. But I had every intentions to keep making the payments. I just didn't have the money to do so.
And I recognize that you may not have been working during the summer, and so that may have caused, I guess, some concern about your ability to pay. But you knew that when you entered into the previous payment arrangement that you would be required to make those payments even during the summer when you will not be working at the Lansing School District. I don't know what you do during the summer, but if you're not working and you have bills, you probably should get a supplemental job during the summer to pay those bills.
That was
outside
my
of
plan.
that,
I'm sorry.
outside of that, you started back working in September, according to what you've stated, and you made, it appears, one payment.
Yes, because I had to catch up on other bills. And I know that that is a bill too, but I had to catch up on other things. And that's when I made the payment in October. And then I found out later that they were going to start garnishing me. So I just said, well, I'm not going to make any payments if they're going to take it from me.
Okay, so you said you also got sick. Was that in between the summer and now?
I had to have a surgery in May.
Yeah, we don't need to know what happened. I just wanted to know the time frame. So you had surgery in May?
Yes, and it was a while before I recovered.
Okay. All right. Well, I'll give you two options. Counsel, I can put you in a private meeting room and you can discuss further in private her financial situation and see if you can come to a resolution. Otherwise, I'll make a decision when you return.
That's fine.
Okay.
Okay, let me put you in a private meeting room. Okay, on the record in the matter of LVNV Funding LLC versus Christy Hall. And file number 23-00564 GC.
Good afternoon, Your Honor. Preston Nate P77884, appearing for LVNV.
Is Christy Hall present? Okay, we reset this matter because on November 7th, we were told that the defendant did pay. The funds had not cleared, so we just set this for a control date.
Okay, yeah, that sounds good. The funds have cleared just fine, so we really just need a dismissal entered on this case, and I can get that to you if you need me to.
Yes, if you could file your dismissal, this will resolve this matter.
Very good. Thank you, Your Honor. I appreciate it.
Thank you. You're all set. On the record, in the matter of Hamilton Road LTD versus Claude Miller, file number 23-01344 LT, counsel appearance.
Gene Turnwald, Your Honor.
Your Honor, for the record, Darwin Fair on behalf of the defendants, P 31-266.
Gene Turnwald on behalf of Hamilton Road Limited.
Okay, today was the date set for an objection to entry of order under the 7-day rule. And Mr. Turnwald, did you receive the defendant's objections?
We received the objection and we responded. It's our position the objection is inappropriate. We asked that the court sign the order as submitted. He has
When
not
did you
provided.
respond? Because I don't have it in my file. When did you respond to the objection?
November 29th.
It's not in my file. Please state on the record the reasons why you, or what your response relied on as to why his objections are invalid.
It's inappropriate to argue about an order that hasn't been entered yet. The proper form in objection to the entry of the 7-day order is for Attorney Fair to submit a substitute order and state why the substitute order is somehow more accurate than the order that's been proposed for entry. He wants to argue the case, argue the merits of the order when the order hasn't been entered yet. First, we enter the order. Then if he has an objection, to file it. And his objection, by the way, is entirely inappropriate. He seems to mislead the court, or at least intended to, was our perception, that he didn't know of the hearing when he knew perfectly well the hearing. And in fact, his office contacted our office and told us when the hearing was. He entirely knew about the hearing, and his complaint appeared to be that he didn't get a written notice of the hearing date. But be all that as it may, we submitted an order under the 7-day rule. He has not submitted a substitute proposed order. Once that order is entered, then and only then he can file an appeal or a motion for reconsideration in regards to the order that's been entered.
Mr. Fair? Did
Well,
you?
Your Honor, I'm sorry.
Yeah, I'm not gonna engage in the back and forth with you and Mr. Turnwald because I didn't have his response. I wanted him to put his reasons on the record. But my first concern or question is, why didn't you appear?
Okay, well, and Your Honor, if you didn't get his response, then you didn't get my response to his response. But direct answer to your question is that, number one, my office did not get written notice. Number two, Mr. Turnwald makes reference to a conversation between my office and his office. And my office characterizes the conversation a little different. Judge, only thing I can tell you, when it comes to motions for reconsideration, we can't answer a motion for reconsideration until we have an order. My office routinely checks the register of actions to see status of the case. When they saw that, they assumed that it was a control date because they hadn't seen an order allowing me to reply to the motion for reconsideration. And so that is the reason they called to see if there was an order. And Judge, I can tell you.
Did the register of actions say it was a control date?
I don't know, Judge. I didn't look at the date, but Judge, let's assume.
It stated it was a hearing. Not only did it say it was a hearing, we have evidence in our file that clearly states that written notice was mailed to your office on November 9th of a hearing date on November 21st at 2 p.m. I did not order you to respond because I ordered you to appear in lieu of a response.
Okay, and Judge, I believe you. I did not, as an officer of court, I did not get it. And if I had gotten an order from this court saying I could respond to a motion for reconsideration, I would most certainly have done that.
I didn't ask for any response. I asked for an appearance, and I sent a notice to appear to your office. I believe your office was aware. Even based on the way you termed it, you say you didn't receive written notice, which we believe to the contrary because our records reflect that we sent you. The court itself sent you written notice, and then your office was aware, but you made a determination that notice that you seen or that you were advised of that stated there was a hearing on a motion was a control date. And that would be incorrect. It was not a control date. It was the date for a hearing.
No, Judge, I get the point that the court was making, but let me just make sure that the court is clear. My office did not get written notice. I believe that it was sent, but my office didn't get written notice. If they would have gotten written notice, they would have given me written notice. My office routinely reviews register of actions to determine if what's the status of the case is. And we filed an affidavit to that effect. My office manager said that she called Turnwall's office to see if there had been an order for me to respond to the motion for reconsideration. Judge, I've been at this for 43 years. I do not miss court dates. And I definitely won't miss a court date that's a Zoom court date that I know of. There's just absolutely no reason for me not to. But what happens is I have a staff that is a very professional staff, and they know full well that when it comes to motions for reconsideration, you better stay away from those because you can get in trouble if you respond and you didn't get a court order. But I hear what the court says. They wanted me to show up. I would have showed up. I'm sorry I didn't show up. If I had known, I would have showed up. The affidavit filed by my office, they state that they didn't tell me that they saw that on the register of action, and they wouldn't tell me because they're always looking at registers of action. But they know that if they get something in black and white, that there's a court appearance, they know to put it on my calendar, tell me about it, and Judge, just like this hearing, I'm here. And I understand what the court is saying, that they haven't received Mr. Greenwald's response. Well, I filed a response to his response.
There's no way as a attorney that I would believe that it's reasonable that your office, whether it's you or your secretary or your legal assistant, would see that there's a court date on a register of action, and we don't call the court to confirm if we didn't get a notice. Why would we call counsel? We would call the court. And based on what Mr. Turnwald is saying, that you called his office or your staff called his office and told him about when the date was. We have notice that was sent to both parties. I allowed Mr. Turnwald to give his reasoning on the record as to why he believed the court should reconsider. I don't even believe, based on those reasons, that I would have made a different decision if you were present.
Okay, that's fair enough, Judge. It's fair enough.
Yeah. I don't believe that would change or impact my ruling. And so I'm really, quite frank, I don't want to go into the back and forth with you and Mr. Turnwald on your beliefs as to whether or not this case should be stayed. I don't believe that you have properly sought a stay on this case. And so that whatever you got going on over in the circuit court, there's been nothing that's been provided to me that shows me, or in the Court of Appeals, shows me that this case should be stayed, or that it has any bearing on the eviction at this time.
Well, Your Honor, if I may, and I'm right now, I've got to be careful, but I don't think there's any question that my clients have filed an appeal that is currently for the Michigan Court of Appeals. I believe the last time we were in court, you ordered my clients to be there, and my clients came to court, and we told the court that we were before the Michigan Court of Appeals. They've been making escrow payments. They're current with their escrow payments. And my understanding, and I can go back and look, Judge, is that this case was stayed, pending the outcome of the circuit court case. And that's why they're making escrow payments, and that's why they showed up in court.
But then we had a motion to reconsider.
And I get that, Judge. I do. Judge, I do get that. And Judge,
Yes.
you know, the court
Yes,
rules.
okay. We'll let Mr. Turnwell speak now.
Okay.
Your Honor, once again, we're being misled. Mr. Fair's clients are not in the Court of Appeals. His appearance represents the occupants, the Davises. The parties in the Court of Appeals are not represented by an attorney. They're not the same parties. Also, the escrow amount is not been paid. If you check today, yesterday, the day before, it was due on the 15th. It's not been paid.
Okay.
Well,
Nonetheless, I'll let you all continue to have your back and forth at your own leisure. I'm going to grant the order that was submitted under the 7-day rule, and I'll see you all at your next court date.
Thank you, Your Honor.
okay. All right.
Thank you.
Thanks, Your Honor. Well, now, can I ask that if Brother Turnwell gets that order, that he email it to me, and I can assure the court I will have my office check every day to make sure that we have that signed order, because we have to file an appeal within 7 days, which I can assure the court that that's what I'll be doing, because there's a appeal before the Michigan Court of Appeals.
Okay, sounds good.
Thank
Mr.
you.
Turnwell will do that. Thank
I'll do
you.
that. Thank you.
Thanks, Your Honor.
Thank you. Who's on the Solero 5G?
Can you hear me? I'm sorry.
Yes, what's your name, ma'am?
Angela Welch.
Ms. Welch, is that the one that was dismissed? I think your case was dismissed.
Judge, Miss Welch is the one that we just heard earlier on mine, that we already made a determination.
Okay, sounds good. Okay. Okay, Ms. Welch, yours was not dismissed. That was the one before that. Okay, let me handle another matter, Ms. Welch, and then we'll get to your matter. As your matter, you should have been here at 2 for yours. I see.
Yes, ma'am. Sorry about that. Thank you.
Anthony Pryor, present. Are you Mr. Pryor?
Yes, ma'am.
Okay, on the record in the matter of Anthony James Pryor versus Simon Zaney, file number 23-02133GC. State your name for the record.
Anthony James Pryor.
Mr. Zaney is present via Zoom. Please state your name for the record.
Simon Zaney, Z-E-I-N-E.
Okay, today was the date and the time that was set. Oh, I think I have it here, so I have it, Sean. I'll take that file. Oh, that paperwork, thank you. Today was the date and the time that was set for a motion to set aside a dismissal. Mr. Pryor, you filed a motion to set aside dismissal. So you came before the court. This court, I believe it says explaining the above said claim is meritorious, and asked the court to reinstate this claim and set it for a new date. Yesterday, when logging into Zoom, I entered the room ID and said, once my name appeared on the screen, I'd be admitted to the hearing. That didn't happen. So I came to the court. I'm not sure what that word says, but the but the dismissal was already put through. I have pictures and videos. Okay, so when your case is dismissed, you did have a court date that was scheduled on November 21st. Looks like you came the next day and filed this motion to set aside. And you attempted to log into Zoom, you said?
Yeah, I was actually on Zoom that morning, the day of the court hearing, and it said your name at the bottom of the screen, and I could probably do it again right now to show you. I had the correct information according to the court clerk that was out in the hallway, but it just said as soon as my name appeared on the screen that I would be admitted to the room. And then it never did that. So about 20-30 minutes into the hearing time, I jumped in my truck with it on my phone and I drove down here and came upstairs, and the courtroom was already dark and you guys were already gone. It was pretty quick. I guess that was one of the last cases or something probably, but he just said that I had to come back the next day and request that it be reset. And I mean, no intentions on missing it at all whatsoever. I mean, it's a pretty serious case in my eyes.
Yeah, well, the way our Zoom works is if you're in our Zoom waiting room, it pops up and tells me someone's in the Zoom waiting room, and we admit everybody in the waiting room. And if you were on time, you would have been admitted. And if we didn't know what your name was, because we admit you even if you don't put your name in there, anybody in the waiting room gets admitted. So you did not join my courtroom that day because we never saw you. And I give a grace period. So that means that by the time I finished my docket for that day, you had not appeared. So in order to have a dismissal set aside, you gotta give me two things. You gotta give me a good cause as to why you missed court, which I believe you have, good cause, but you also gotta give me a meritorious defense. And so you believe you have a good case in your eyes. I don't want you to get into your proofs because that's not what today's date is for. This is, and I know nothing about this case, obviously. So this is, you're suing Mr. Zaney in this matter?
Yes, ma'am.
And you believe that you have a valid or meritorious case, I presume, correct?
Yes, ma'am.
And this is over the replace of a roof?
Yes, ma'am.
So it's a breach of contract is what you're alleging?
Breach of contract or poor craftsmanship, possibly a combination of both. There was some cleanup work that was never completed, and upon me going into it myself in the attic, and then opened up a whole can of other worms, of other problems.
And you believe that was a result of those services that Mr. Zaney was supposed to provide?
Correct.
Okay. Mr. Zaney, did you want to respond to the motion to set aside the dismissal?
Well, to be honest with you, Your Honor, I would say I was here, I was present at this. I did not see a list who's in the courtroom with us, and I didn't see him. I don't believe this is a accurate detail of what work we did, and the understanding of what was to be done on the roof was very clear. And I would ask that, you know, if we do move forward with this, that I be allowed to get an attorney to help me facilitate, getting this taken care of.
I'm going to grant the motion to set aside. I do believe that you have a good cause, and based on what you've told me, it sounds like you have a legitimate complaint. I don't know what the merits of the complaint is. I guess we'll find out as the case progresses. So we'll go ahead. You don't need to show me the Zoom. I know people have issues with Zoom all the
I
time.
screenshotted it though that morning just to show you that day, just to show you I was sitting there and it showed your name and everything.
Oh, I'm sure.
just
What
was
time
telling
was it?
It says 2:10 p.m.
Yeah, we would have been in here, so I don't know what would have happened, but I'm gonna tell you what, it wouldn't be the first time that there's been a technological issue.
Yeah.
So that's why I said from the beginning that I believed you had good cause.
Yes, ma'am.
But I just needed your meritorious defense. So I'm gonna set aside the dismissal. This matter will be set for a pretrial date. And then, Mr. Zaney, you have an opportunity to hire an attorney, and they'll file their appearance. And if there's an issue with the date that's set, they'll let us know and we can rearrange that date, okay?
I just
Thank
have
you,
one
Judge.
request.
What's your request?
He has family that's an attorney that it not be his family.
You don't get to pick someone's
Okay.
attorney.
I'm just saying, 'cause he has a brother that's an attorney.
Yeah, we're very familiar with,
Okay.
with,
All right, all
he was
right.
in the
I'll make sure.
courtroom yesterday or today. We don't get to pick his attorney. That's up to him.
Thank you, Judge.
He has the right to
Funny, I
counsel.
know.
He has the right to counsel.
I know.
You have the right to one too if you want to go and hire your attorney. Okay? Okay.
Thank you.
We'll give you a notice to, actually, no, civil will send you a, next court date. You're all set for today,
Thank you.
sir.
I greatly appreciate your time.
Thank you. Thank you, Mr. Zaney. What's this, young lady's name here? Oh, actually, sir, Mr. Pryor. I need you back up here. I forgot I had another matter for you. Record, the city of Lansing versus Anthony James Pryor. File number is 23L2781391. In this matter, it appears you are in warrant status before Judge Flores for failure to appear for your pre-trial. Improper plate. You're supposed to be before him on,
No.
you were supposed to be before Judge Flores on August 21st.
And I went before him and also the city attorney, or the prosecutor, one or the other, I'm not sure exactly which one was in the courtroom. And they were setting it aside because I have an issue with Carvana. I bought a car in September.
I don't want to hear any other term. It's not even my case. I don't care less about that. You're just before the court and you have a warrant, so I have to address it. So all that stuff you want to share, you got to share it before Judge Flores, not me.
I already did.
No, well, not according to his paperwork. You're in warrant status. You failed to appear. You originally had a court date on the 31st of July. This looks like he then set it for August 21st and that you failed to appear. You cut me off one more time.
Sorry.
You did originally look like have a warrant that he quashed. That was the July warrant. You failed to appear in August.
I emailed the prosecutor all the information.
I don't care what you emailed. You got to come to court if you have a court date.
Yes, ma'am. I was told that it would be removed and I wouldn't have to show up. I just needed to email them the proof of what was going on with Carvana and refinance the car here in the state of Michigan.
I thought I told you I don't really, this is not my case.
It's
I don't want to
very-
know any of the issues. I just want to advise you that you missed a court date, okay?
So what do I have to do?
You're gonna get a new court date. You have to appear for the court date,
Yes, ma'am.
okay?
Yes, ma'am, I would.
That's what you have to do.
Yeah, for sure.
Are they gonna give us a new date? Or do we need?
I've had that car for 3 years and it's been here in Michigan for 2
Sir, I don't,
They're fighting.
sir, I don't wanna hear about it.
I know, it's a disaster.
January 9th at 10 a.m.
January 9th at 10 a.m., you'll be next door at Judge Flores, and you can feel free to share all those things that you want to get off your chest. But we don't want it on our record, okay? Because you have the right to remain silent. Anything you say can be used against you. And frankly, it just is not appropriate for you to be sharing all that right now, okay?
Yeah,
So we'll get you a copy of your notice to appear, and then you can leave here. Remember, you report to court
I sure will.
for us January 9th, okay?
Yes, no problem.
Thank you. Is this Cora Taylor? Or that's Cora Taylor?
Sure.
Okay. I don't know if the attorney is here for that. Is there an attorney here for that matter? Maybe it's a one. Okay.
I'm here for that, Judge.
Okay. Did you need to meet with her privately?
Yeah.
Oh, your computer is got a bandwidth issue. I didn't hear what you said.
To me there if I could.
Okay, we'll see if we can get her in a meeting with you. It's giving me an alert that you have low bandwidth right now though, so I don't know how good your connection is.
Okay.
Okay, let's get her on Zoom. Okay, back on the record in the matter of Plaza Services versus Angela Welch. Counsel appearance.
Thank you, Judge. Attorney Ashley Nonis, Hartman, on behalf of plaintiff. Do you mind though if we do Miss Nolan first? She's been patiently waiting. And since Miss Welch was late, I'd like to see if I can get Diamond out.
Okay, sounds good. Okay, back on the record in the matter of credit acceptance versus Diamond Nolan. I sent the parties to discuss this matter privately to see if they could come to a resolution. Were you able to do that?
Unfortunately, Judge, we're not. I mean, it was a beneficial discussion, but I'm not sure the defendant's in a position to accept the terms. I had offered the same terms, cure the arrearage, and we can go back on the installment payment order. I don't think she's able to do that. So I think maybe we should just proceed with the argument and see where it goes. And I did tell her that whatever happens today, we can try to work it out in the future anyway.
Okay, so I already know what your client's position is. That's how we ended up here in the first place. But Ms. Ward, I believe your position is that you are not able to catch up on that lump sum of the arrearage. You just want to continue to make payments at this point. Is that accurate?
Yes, I would.
Okay, and you were previously making a payment of $50 a week, or how often was it again?
Every 2 weeks.
You know, if I was looking at the right file. Okay. Okay, I can understand why, based on her health and her employment, why she would have gotten behind. And she's currently behind $450 still, or is it more than that?
Yeah, it would be more than that. As of today's date, it would be $650 because it was the additional 2 months she missed at $100. So $650 would be her arrearage.
Okay, and she indicated that she didn't pay the last couple months because of the garnishment. I'm going to allow her to continue on her payment plan. At this point, I'm going to set it for a 90-day review because I am going to require that you pay $50 every 2 weeks. And then we'll evaluate that status in the next 90 days to see if that amount can be increased, okay?
Okay.
Okay, and Judge, just for the record, and as we requested in our response, under the Michigan court rules, we are entitled to costs for the entry of a new order. So I would ask that the court grant us costs.
Okay, your cost is
In a minute or so, if there's any problems, I'll be back.
just a moment. Okay, thank you. Your cost is granted in the amount of $350.
Thanks, Judge. Do
Does
you need me
that
to
get,
draft? Oh, I'm sorry.
sorry?
when does that have to be paid, or does that get added on to the balance?
That'll need to be paid. That'll need to be paid to the plaintiff's counsel as a part of their need to defend this motion in court. What I'm going to do, counsel, is require you to provide an order to the court. And I don't know if you're aware, but we are e-filing now, so you would need to file electronically. And then we will make sure that the defendant gets a copy of that order, okay?
Absolutely. And then to answer Ms. Nolan's question, and if this is okay with the court, we can make the $350 in costs due in 90 days. So that way, when we return, we can evaluate if that has been paid as well.
Okay. Judge, may I ask when the garnishment will stop?
The garnishment will be suspended immediately so long as you are in compliance with the payment plan of the $50 every 2 weeks. And now, because you have this additional cost that you need to pay, it's probably in your best interest to pay a little more and make sure that they're understanding that that's being applied to the court costs, okay? But you
Okay.
need to make sure they understand that when you pay it. Don't send them $75 because they'll just attach that to your underlying bill. You need to let them know this $25 here is for my payment on my court costs, okay?
Thanks,
Okay.
Judge. I appreciate that because that's true.
Okay.
Okay. Do you have any questions at this time, ma'am?
No, I just want to say thank you, Judge, and thank you to the attorney as well.
Okay, you're all set. You're welcome, and you're free to go unless you have any questions for me.
No, I don't. Thank you very much.
Happy holidays, Ms. Nolan.
You as well.
Thanks.
Whoever's on the iPad needs to join the breakout. Whoever's on the iPad needs what? To join the breakout room. I don't think she knows. Can you go help her join the breakout room, Sean?
Yes, sure.
She won't. She's in. Okay, now we're back on the record in the matter of Plaza Services versus Angela Welch, counsel appearance.
Thank you, Your Honor. Again, for the record, Attorney Ashley known as Hartman on behalf of plaintiff.
Okay, and so this is the matter that was set for review. And my understanding is that Ms. Welch has not made any payments since our last court date. Is that accurate?
That is accurate.
Okay, and so it was the plaintiff's intention to file a affidavit of non-compliance. Is that still your intention?
Yes, Your Honor.
Okay, Ms. Welch, why have you not made any payments?
I'm sorry, Judge, but I was under the impression that the garnishments were going to be stopped, and I asked, do I still need to pay $20 or what I was offering, and I thought that I was told no, we would come back in December to discuss everything.
I'm not sure where you could have possibly got that understanding.
I don't know. I mean, I do have a hard time comprehending things, so I'm sorry for that. I did not understand that I was supposed to make the $20 or.
In Your Honor, she did receive the order.
I'm aware of that, and not only that, this is what we discussed on the record. You, ma'am, were the one who requested an installment payment order. You didn't have a problem understanding that. Is that accurate?
No, I understand that. I asked for the $20 order, but I guess I did not understand that when the garnishment stopped, that's when I needed to start. I thought that they would start in December when we reviewed the case and I got caught up where I needed to be doing.
No, ma'am. We went over this in court and we sent you a copy of my order, which very clearly states, actually, you filled this out, not me, I just signed it, that you're gonna pay $20 every week, starting September 1st, 2023. And that the writ of garnishment that was issued on February 6th would be suspended so long as you were in compliance. You completed this paperwork, all I did was sign and grant it. So to come before the court and tell me you misunderstood what you asked me to do makes no sense. So your motion to set aside, your motion or your request, I should say, to continue in a payment plan, I'm not gonna grant if you made one, because you didn't even, it's $20 a week, you didn't even do it, and you want me to believe that you misunderstood what you asked me to do for you.
Well, I do, because I do have a learning disability, ma'am. I'm sorry, I did misunderstand. I honestly misunderstood. Yes, I agreed to do the 20. Yeah, I know.
This is your handwriting. This was your handwriting, not mine. So you can't use the disability because you filled the paperwork out. You did an excellent job filling it out, actually. All I did was grant it and sign it.
I did have help filling out the paperwork because I didn't understand. And the $20, I'm sorry. I honestly thought that starting in December, because I asked, so this gets stopped right now. Yeah, I'm sorry. I have had a lot going on.
Who did you ask?
I thought I asked in court, do I have to start making the payments of the $20? And when I heard, okay, it's going to be postponed, I'm sorry. I honestly, it's an honest mistake. Sorry, I did not understand that I was supposed to be doing the $20. I thought I was going to start in December when we came back to review. That is my mistake, and I apologize for that.
You received an order that you saw, that you requested, that said you were supposed to make a payment September 1st of $20?
Yes, I did receive it, but I didn't. I don't I guess I don't even understand why I didn't understand it, because I did get it. I just didn't realize that it
If
started.
you don't understand it, I don't understand it either. I think we're all on the same page with that. So the plaintiff is going to file a affidavit of non-compliance, and when the court grants that, you'll receive a copy of it. Today was the date set for review anyway, so there's no motions or decisions to be made at this time. So you're all set for today.
Okay, and what is the motion? I'm sorry, what did you call it? The motion for what?
The plaintiff is going to file what's called an affidavit. It's a sworn statement stating that you've not complied with the order of the court. And so if they file that and I grant it, then they can proceed with garnishing your wages because you did not comply with your payment plan. Now you can feel free to contact the plaintiff outside of the court, and you all can come to a new resolution. That's between you all. I'm not going to take part in that, and I'll look forward to any future filings once they're filed. At this time, you're all set for today, okay?
Okay, thank you.
Thank you.
Thanks, Judge. Have a great holiday.
Same to you. Ms. Petrosky? Did I miss something?
Hello, excuse me, sorry. Hello, Your Honor. I believe Mr. Lee had contacted me about doing an emergency bond hearing for tomorrow at Chambers. So I was just waiting on Zoom until he was present, ready.
I didn't say I was doing an emergency bond motion today.
It's not today. It's scheduled. It's not today.
Tomorrow Chambers, Your Honor.
It's scheduled on the docket, just not today. It's on
There is a,
28th.
So on the 28th.
there's a lady in the hall that's been here today trying to see you about this. She's the caretaker of the children right now. Two years children. And I advise you that.
I don't have any motions.
Ms. Simmons, or rather Judge Simmons, sorry. This is Miss Aubrey. Miss Aubrey is.
We're not on the record.
Sorry?
We're not on the record on anything.
I said the
No, I
28th.
was just talking.
Okay, there's supposed to be a motion here on the 28th.
Yes, yes. The reason we came, and with all due respect, Your Honor, we're not trying to force anything on the court. Miss Aubrey came to our office and asked me if I would approach the court on her behalf and ask for an emergency bond because of the child caring situation that she's encountering. If the court,
Like child care situation. I've not, someone's got to pull the file. I'm in the middle of a civil docket.
and then we told her that, and we understand if this is not possible. If it is, thank you so much. Whatever the court decides.
We need to have Miss Lady in there back in here for her hearing. Oh, there she is. Ms. Taylor, can you hear me?
Yes, Your Honor, I can.
Okay, on the record. In the matter of First American Auto versus Cora Taylor, file number 23-01512 GC, counsel appearance.
Good afternoon, Honor. Robert Zelinski on behalf of plaintiff P69250.
Okay, and then Ms. Taylor is present. She's actually in the courtroom, but we've placed her on the court device for convenience of meeting with you, counsel. And today was the date that was set for a pre-trial. We reset this matter because the defendant was previously having issues starting her audio. And I do see where, counsel, you did file a pre-trial statement. Were you able to complete that today or come to a resolution?
No, Your Honor.
Okay, so you weren't able to complete the joint pre-trial statement?
I wasn't aware we were supposed to do that or try to do that. I don't know if I could accomplish that with Miss Taylor.
And why is that?
I don't know if she'd be receptive to doing that with me right now.
Okay.
I can take a shot at it.
Ms. Taylor, I don't understand what she'd be receptive to doing. We're going to do a joint pre-trial statement today. That's the only option, Ms. Taylor. What is the issue?
He was asking me, was I receptive into paying an amount of money? And
okay,
I told him,
you don't have to be receptive to settlement if you don't want to, but the joint pre-trial statement is just so that we can know certain facts or information about the case so that we can know how to set it for your next court dates. So to get it ready for trial.
Okay, no, I'm not receptive to what he was, I'm not receptive to what he was proposing.
Okay, sounds good. So that's private negotiations and you have the right to not move forward with negotiations. You have the right to have trial in this matter. And so he's provided the court with a pretrial statement. He states that the issues essentially is whether or not you owe a balance stemming from a default on a vehicle lease. That's what they're suing you for. You understand that?
Yes, I do.
Okay, he says that the pleadings are the things that they file in the court, the paperwork, the complaint, if there was any motions or anything like that. He said that that's in order. I agree that that's in order. I don't see that you have filed anything such.
I did.
I'm sorry. I don't see that I don't see that you filed anything that would cause the pleadings to be out of order. Okay.
Okay.
Okay, there is a section here that says motions pending and expected. It says that the plaintiff expects to file a motion for summary disposition. And so that's essentially saying that they're going to file a motion and ask the court to review everything that's been filed so far and grant judgment in their favor based on that. And so other motions obviously can be filed. There could be a motion for summary judgment filed. You can file a motion to dismiss if you'd like. I know you're representing yourself, but if you're going to proceed in the case, you're going to probably need to Google some of these things or get a court rule book so that you can understand what we're talking about, okay?
Okay.
Okay, so there's going to be a potential motion for summary disposition. I'm also going to highlight on this particular form that there may be motions for summary judgment also, and that those will be heard by a certain date. I'll put a date in here in just a moment. There's no other cases pending that need to be consolidated involving these facts, correct?
Correct.
Correct.
Okay. And then there's no admissions of fact, meaning you haven't admitted to anything. Is that correct, Ms. Taylor?
Correct.
Okay. And so far they list their exhibits as the lease agreement or the contract documents, your payment history, and your account notes. You don't have any exhibits listed right now, but would you like to list some exhibits? You don't have to do it right now because you may not know what you want. to list?
I'll admit them later.
Okay, so I'll note here that exhibits will be exchanged during the discovery period I'm going to give you in just a moment.
Okay, thank you.
Okay, so discovery, plaintiff does not request any discovery. So there's not going to be any formal discovery, meaning no depositions, no request for interrogatories. Interrogatories are a set of questions that they would send you to answer, or a request for a production of documents. There's a list of documents that they would ask you to submit. So we're not going to get into that level of discovery, but you all will exchange your exhibits, and I'm going to give you a cutoff for that of March 1st, 2023, okay? I'm sorry, 2024.
Thank you.
Because that's where we are now,
Your Honor?
2024. Yes.
Your Honor, could you strike the account notes from the plaintiff's exhibits?
No problem. I don't perceive this to be a case that requires an expert witness. Am I wrong?
Correct, correct. No, not
Okay,
for
an expert.
plaintiff.
Thank you, Ms. Taylor, for your information. An expert witness is not the same as a lay witness. So if you want to call someone to testify on your behalf, unless they had a specialized or specific knowledge based on their background to be qualified as an expert, they would just be a lay witness, okay? So I don't believe that this kind of case needs an expert witness, okay?
Thank you.
Okay. Damages is what they're seeking for judgment. They're seeking $2,700.65. There's no joinder of claims that I'm aware of, and there was no demand for a jury trial, I believe. Let's double check. Oh, there was no demand, and so I believe this is a matter that will be set for bench trial. We don't think it'll take longer than 2 hours. Is that correct?
Correct.
I'm good.
That's the top end.
Okay, your jury trial date will be set after March 1st. It states here that the plaintiff believes the possibility of settlement is high. Do you think that you'd benefit from mediation or case evaluation?
Based on our talk before, I thought it was high going in, but no longer. I don't think that would benefit.
Okay, I'll move to low. I'll strike what you put and put low, and I won't order evaluation or mediation at this time. What I'll have is Ms. Taylor can come back here before she leaves to sign this paperwork. Any motions for summary judgment or disposition must be filed no later than the 30th of March. And we'll make sure that the trial, I'm going to actually put here, the trial will be set after those motions are heard, okay?
Okay. Do you going to pick a date after that on a particular day, or just send the motion in and get a date, or call in and get a date, Judge?
That's correct. You send your motion in and you get a motion date at the time that you file that motion.
Okay.
Okay, and so I already have your signature here, and we've gone over the record with the changes that you've okayed the court with making. I'll date this for today. We'll have Ms. Taylor sign here today, and then this will be what we use to kick out the scheduling order as to what your next court dates are. Okay, Ms. Taylor?
Yes.
Okay, do you have any questions?
No, thank you.
Okay, you
No,
can
yeah.
come back. Thank you, we're off the record. Ms. Taylor, you can come back to the courtroom.
Okay, thank you.
Thank you.
Mr. Nichols, he was in a exam this morning. I think the same was early. I did reschedule the hearing.
If he wants to wait his client, severe, fine.
Well, it looks like Paige is gone. Yeah.
Thank you. Paige can log, you have her log back in, I suppose.
consequences.
You're all set, ma'am. Johnson first. Okay. All right, we're on the record in the matter of the people of the state of Michigan versus Rajon Johnson. I have file number 23-2022. 23-3166, 23-02919, 23-02932, 23-03221. Council appearances, please.
Assistant Prosecutor Paige Petrosky on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Mr. Johnson.
Assistant Public Defender John Lee on behalf of Mr. Johnson as well.
Okay, thank you. Mr. Johnson was present earlier from the Ingham County Jail. Counsel, would you waive his appearance for this purpose?
Yes, Your Honor, I would.
Okay, and so we wanted to, and we apologize for the short notice, the court, or my courtroom will not be available for the next 7 days. And so we got this notice yesterday, so we tried to get it scheduled immediately to address the issue of competency. I do have a report dated December 11th. Did you get a copy of that report, counsel?
I did, yes.
I did as well, Your Honor.
Okay, and so the understanding, there's two reports, I should say, and clarify for the record, because he was ordered to undergo evaluation as to competency and then also as to criminal responsibility. The competency report opines that he is competent to stand trial. Any reason to have objections to the body of that report or the conclusion?
No objection from the people.
And on behalf of Mr. Jones, I would not object. As the report notes, he is not currently advising he has any mental health diagnosis or is receiving any treatment. I guess I would have to defer to the experts at the CFP about his present competency. I also would concur from my reading of our notes and my attempts that he has not, to my knowledge, been willing to speak with anyone from our office up to this point. So I do note the unwillingness to communicate about his legal matters.
Okay, that appears to be consistent with the next report, which is relative to criminal responsibility evaluation. He declined to participate, and so they were unable to complete that portion of the evaluation. I do have notes in our file, and again, this is a matter where there's a charge of unarmed robbery and an aggravated assault, but that during the arraignment, the defendant was extremely belligerent, and the magistrate had difficulties with his arraignment. And then at the first pretrial counsel, you did report your concerns about his cognitive issue. And so I don't know if you want to have us reorder to attempt a criminal responsibility evaluation, or do you want to continue with this matter and abandon the idea of the criminal responsibility? I'm not really sure how far along we'll get in this, if he's going to continue to decline to participate, but again, he does have the right to remain silent. So maybe he's just invoking that right. I don't know.
I guess I would ask the court to kind of abandon it at this point. If Mr. Johnson desires at a later date to pursue an insanity defense to either of the felony charges or the misdemeanor charges, that's certainly something we could repetition the court to send him. But I think to continue when it's being clear that anything court related, he's refusing to answer their question, and anything mental health related, he's refusing to acknowledge any diagnosis. I don't know that we would get a much different result if the court were to reorder him right now.
Okay, very good. So the court will adopt the reports both as to competency to stand trial and criminal responsibility. We'll incorporate those reports into the court file and the record, and then we will get these matters set for a new probable cause conference and preliminary examination, unless you don't believe we need another probable cause conference.
I would like a probable cause conference to be set, especially because my office, to my understanding, only filed an appearance on one of the misdemeanors and one of the felonies. And so we're going to have to file an appearance on everything now that competency has been resolved.
Very good. We will get you new PCC date and then new exam date. Just a moment. For the PCC.
January 25th at 8:30.
January 25th at 8:30 will be the PCC.
And then February 15th.
February 15th, at what time?
8:30.
At 8:30 for the exam. And then we need to get some pretrial dates on the misdemeanors. Oh, wait, there's another felony. There's 2 felonies. We'll set those for the same date. Okay.
And we can do January 16th at 10 for the misdemeanors.
January 16th at 10 for the misdemeanors. Any additional matters on these files today?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor.
January 16th. Okay. Off the record on those matters. Thank you, Mr. Nickel and Mr. Trustee. We're going to call the next case in just a moment.
Okay.
Just apologies for not being able to appear earlier in the morning.
Oh, no problem. I think I wrote the note in the wrong file. Thank you. Yep.
Have a good day.
Same to you. Thank you. This is FYSM. Okay, on the record in the matter of the people of the state of Michigan versus Tamara Chambers, file number 23-02988. Council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Tamara Chambers.
Okay, and are you waiving Ms. Chambers present?
Yes, we are waiving her appearance.
Okay, this matter is scheduled for a bond hearing, bond modification hearing on the 28th. However, you appeared before the court today as a matter of some emergency.
Yes, Your Honor. And thank you so much for allowing us to appear. Ms. Chambers's mother, Ms. Aubrey, who is here in the courtroom today, has been watching Ms. Chambers's children while she's incarcerated. Apparently, there is no plan B. There is nobody else available. And the challenge that Ms. Aubrey faces is that she's returning to work tomorrow. She works the midnight shift. And that means that tomorrow she will have to start making a choice between going to work or staying and watching the children. She has informed me that she will stay and watch the children because that's the #1 priority. But she fears that she risks losing her job in the process. She does rent a home and fears that she will risk eviction and severe consequences as a result of having to make that choice. So we come before the court fully aware of the fact that the court has already made some decisions in this case and that we completely respect and ask the court if it would consider establishing some type of bond for Ms. Chambers. Her failure to appear, she explains, is related to COVID, something out of her control. Her intentions on the matter, we think she displayed good intentions when she turned herself in voluntarily. to try to get the matter resolved. And so we just asked the court if the court would consider bond for Ms. Chambers.
I don't know how I can meaningfully address the bond issue without a defendant to talk to.
I understand the challenge there.
This is an issue that she was supposed to appear in October. Turning yourself in December, you don't get a gold star. She's not here. And then I had a bond violation in between there. I can't even go over her bond conditions. And she was arraigned on December 11th. There could have been a motion filed on December 11th. Thereby, that matter would have been set for a hearing this week and not next week. There wasn't a motion filed until the 15th. Now we can't even get her here. There's someone behind you is raising their hand. Well, you can speak to him.
This is Ms. Aubrey. Would you be okay with her addressing the court at all? Or?
Please state your name for the record.
Ms. Aubrey. I've been trying to get it done.
To get what done, ma'am?
So she could get a bond. You were out of the courtroom, so we had to wait till you got back, and then you had another big thing that was up in here. Then I was talking with Mr. Lee when I'm able to get a hold of him. It's I took off of work and my time is up, but I cannot leave the kids at home alone. And then I don't go to work, I'm gonna get fired, then I end up there. You know what I mean?
I understand that this is really not your issue because it's not your children. Well, she's your child, but you've been put in a position that is unfortunate. The issue I have here is I don't have Ms. Chambers here to talk to her about her appearances in court or failure to appear in court. I don't have Ms. Chambers here today to talk to her about the alleged bond violations.
I have gone myself to mercy of the court. There's nothing else left for me to do.
What's your daughter's address?
Apartment 1000 Morse River Drive. Yeah, 17.
Even at the time of her arraignment, it stated that she had more, or she had multiple failure to appears in the past. This is not her first case she's failed to appear in court for. So because of that, the court has concerns with her willingness to return to court. I recognize that COVID or getting sick, she said she was very sick at the time of her court date in October, but her attorney had not heard from her and she did not appear to turn herself in at all. She could have appeared via Zoom on October, or she could have came anywhere between October and before December to address the court date and we could have got it reset, but she did not do that. I don't think it's fair though that the burden is placed on her mother to risk losing her job to try to care for the children. For that reason, I'm going to give her a PR bond with GPS tether.
Thank you, Your Honor. Thank you.
Okay, you're welcome, ma'am. So we'll get GPS tether and Mr. Lee, I'll leave it to your responsibility to make sure your client is advised of her bond conditions and reminding her of the no contact order that's in place. And that would mean that she is not allowed to have any communication directly or indirectly with Azusana Thurman, I believe is how that's pronounced. Third party would mean she can't allow her children to call Ms. Thurman either. And so I'm going to leave it to you to remind your client of how serious these violations could be and how we don't want her mom to be in a position where she has to make a decision about caring for her grandchildren or losing her job. But if I have to put her back in jail to make her compliant, I'll do what I have to do. There will be a exclusion zone. She's not to be within 1,500 feet of wherever the protected party lives, works, or goes to school. She needs to make sure she appears to all of her future court dates. Ma'am, I'm sure you're gonna remind her of those court dates as well. We'll cancel that bond hearing for the 28th, obviously, but she does have a court date for January 16th at 10:30 in the morning. And it's a pretrial. So she could appear via Zoom. She doesn't even have to come in person for that. She could appear via Zoom long as she has a video. And then Mr. Lee has information and can assist if there's an issue with her ability to pay for GPS to others, so she can get the applications to apply for assistance for that. Any additional matters for the record? Do you have a question?
What was the time again, 10:30 in the morning?
It's gonna be at 10:30 in the morning, January 16th.
I'll make sure she's there.
And nothing further from the people, Your Honor. Thank you.
Thank you. Thank you.
Thank you, Your Honor.
Thank you so much again.
Thank you. Have a
I really
good one.
appreciate it.
I need you to